एवरीवन, आप सबका मेरे चैनल लीगली पॉलिटिकल पे बहुत बहुत स्वागत है। और आज जो हम लोग डिस्कस करने वाले हैं, एक क्वेश्चन है जो एक लैंडमार्क केस के अंदर सुप्रीम कोर्ट ने डिस्कस किया है, उसको हम लोग आज डिस्कस करेंगे। तो केस का नाम है शरीफ अहमद वर्सेस स्टेट ऑफ उत्तर प्रदेश होम डिपार्टमेंट सेक्रेटरी 2024 का केस है और 1 मई 2024 को आया है। तो इसके अंदर ये एक क्वेश्चन को डिस्कस किया गया है, हम लोग उसको देखेंगे। The question is, when can a charge sheet be said to be complete so that the court can take cognizance of the offence under the Code of Criminal Procedure 1973? तो हम लोग इसको देखेंगे, आज इस क्वेश्चन को डिस्कस करेंगे इस वीडियो में। इस केस के थोड़े फैक्चुअल बैकग्राउंड देख लेते हैं हम लोग। The appellant in this case were involved in a property dispute. The FIR was filed against them under Section 420 cheating, 406 breach of trust and 506 criminal intimidation of the Indian Penal Code. The FIR alleged that the appellants had agreed to sell the property, accepted a partial payment, but failed to complete the registration or return the payment. Subsequently, a charge sheet was filed against them under Section 406 breach of trust and 506 criminal intimidation of the IPC. Then Allahabad High Court dismissed their application to quash the charge sheet and stop the criminal proceedings. The appellant approached the Supreme Court. The Supreme Court has given the decision. Supreme Court has set aside the charge sheet and criminal proceeding against them, and it held that there was no evidence of entrustment. The property was not handed over in trust, rather there was a sale. Therefore, there could be no question of a breach of trust under Section 406 of IPC, and there was also no material to show intent to cause alarm necessary for an offence of criminal intimidation under Section 506 IPC. Then the court further elaborated on the necessary contents of a charge sheet, stating that it is considered complete when it includes sufficient material and evidence for the court to take cognizance and proceed to trial. The court further stressed the importance of charge sheet containing detailed fact of the evidence of the offence and the relevant evidence as mandated by Section 173 subsection 2 of the CRPC. ये फैक्चुअल मैट्रिक्स था इस केस का। हम लोग रीजन पे चलते हैं। इस कोर्ट ने इस डिसीजन को किस बेसिस पे दिया? तो कोर्ट ने इसमें एक्सप्लेन किया इम्पोर्टेंस ऑफ चार्ज शीट को। The Supreme Court emphasized the importance of a charge sheet in a criminal proceeding. It held that an investigation involves multiple stages: visiting the crime scene by the investigating officer, ascertaining facts, making arrests, collecting evidence, and forming an opinion on whether an offence is made out or not. The submission of charge sheet, which is a final step, depends on the opinion of the investigating officer. Upon completing the investigation, the investigating officer must promptly submit a report with the prescribed details to the magistrate empowered to take cognizance of offence. The report which is presented represents the investigating officer's conclusion based on the material collected during the investigation. Now, Supreme Court further explained that the submission of charge sheet under Section 173 subsection 2 of the CRPC, cognizance taken under 190, the summoning of the accused under Section 204, and framing of charges under Chapter 17 of the CRPC are closely interrelated. And the court reiterated that the details of the charge sheet are very crucial for the subsequent procedural stages, and charge sheet is a primary document available to the court at this stage, containing the investigating officer's reason for charging the accused. This helps the magistrate determine if there was any sufficient ground to take cognizance, initiate proceedings, and issue notices and frame charges. Now, court has also explained the term taking cognizance of offence. It clarified that taking cognizance of offence in relation to Section 190 and 204 of the CRPC. It explains that cognizance under Section 190 refers to the judicial act of a court or magistrate in taking notice of an offence, deciding to initiate legal proceedings. This stage requires the magistrate to assess the contents of the complaint or police report to determine if there was a sufficient ground to proceed. More importantly, this evaluation does not involve judging the adequacy of evidence for conviction, which is only decided during the trial stage. Now we come to a stage where we will decide the main idea of this video, or topic which we are going to discuss is when can a charge sheet be said to complete. So in this case, the Supreme Court held that a charge sheet is considered complete under section 173 subsection 2 of the CRPC when it includes material and evidence sufficient for the court to take cognizance and proceed to trial. The evidence presented should prima facie establish the offence if it is proven during the trial. It was held that a charge sheet is deemed complete if the case does not rely exclusively on further evidence, allowing the trial to proceed based on the evidence and material already on record. The charge sheet need not to be overly detailed in its evaluation, as that is the purpose for the trial. And Supreme Court also reflected its idea that through investigation into any alleged offence and provides the magistrate with enough information to decide on appropriate course of action, whether to take cognizance, issue process, or exercise any other available options. The final report or charge sheet must clearly and precisely outline the alleged contravention of the law. Finally, investigating officer must ensure all columns in the charge sheet are thoroughly completed, clearly indicating which crime was committed by which accused and listing the available material evidence. Statement of witnesses and related documents should be included with the list of witnesses. The specific role played by each accused in the crime should be distinctly mentioned for each person involved. By all these methods, the court had tried to explain what were the important ingredients of a charge sheet, what must be included and what must not be included in the charge sheet, so that it will be easy or it will be convenient for the magistrate to take cognizance. So this was all the details that was explained by Supreme Court in this case. And if you like this video, then do subscribe our channel and share the video. Thank you.